Good afternoon, everyone. My name is Madhusudan Sarma, and I welcome you all to this N100 series of lectures. In this lecture series, we are discussing complete polity from mains perspective. That is, we go into the details of what, why, how, and uh, way forward for all the themes that we choose for our discussion. And the themes are chosen based on their probability of being asked in the 2025 mains exam. Good afternoon, Yogesh. In yesterday's class also we have discussed something about the judiciary. We shall continue the same lecture. In today's lecture, we are going to conclude the judiciary. And if you have any doubt from the previous class, you may ask. In today's class, we are going to cover the issue of judicial pendency. There are a lot many cases, 5 crore cases which are pending in our judiciary. So why? What is the reason? What can be done? All those things we are going to discuss. Then we are also going to discuss the issue of tribunals, the issue of alternative dispute redressal mechanism self-discussed in this class. Okay, so let's start the class with the first thing, that is judicial pendency. Do you have any idea how many cases are pending in our courts? Any idea? Any guess? The fact of the matter is there are more than 70,000 cases pending in Supreme Court alone. One court, Supreme Court, has 70,000 cases pending in it. There are only 34 judges in Supreme Court who have to deal with these 70,000 cases. Okay, so per judge there are around 2,000 cases which are pending. Next is, in high courts there are 6 million cases which are pending. 6 million is around 60 lakhs cases. But the vast majority of the cases are pending in the lower courts, and in totality 50 million cases are pending. So it means 50 million translates to roughly 5 crore, not roughly, exactly 5 crore cases are in total. So it is more than 5 crore cases which are pending in our judiciary, and this pendency has been increasing. Before COVID, the number was around 3 crore only. So the number in the last 5 years or so, the number has jumped from 3 crore to 5 crore cases. And then it is not only that the cases are pending, so the courts are not able to deliver justice in time either. So 40% cases in Supreme Court are pending for more than 5 years. A case pending for more than 5 years, you can understand the plight of the petitioner. In fact, the judgment that I was talking about yesterday, for example, the issue related to industrial alcohol, that case was filed in Supreme Court in 2010. It was referred to a constitutional bench in 2010, and the judgment has been delivered in 2024. So it took around 14 years in Supreme Court for that case to be concluded. Okay, so you can give these data are must in case there is any case question on judicial pendency or judicial delay. Okay. There are 8% of the cases are more than 10 years old. So out of the 70,000, 8% cases, around 5,000 or so, are pending for more than 10 years in Supreme Court itself. And similar is the story for the lower courts as well, high courts as well. There are cases which are pending for more than 10 years, even up to 20 years old cases are there. There is a very famous instance, like there was a child who was accused. I mean, I don't know if he was a child or adolescent or not, but he was accused of pickpocketing. That he has uh, stolen the purse of someone. And normally, the conviction in these cases is of 6 months. That's the maximum conviction which is there, maximum punishment. when he went to the court, the guy said that I have not stolen the purse. This is a false accusation that has been made on me. So the court said that obviously then we will go to the trial. There would be like whether we have any evidence or not, it would be looked into. And the trial did not start for next 2 years, and that boy remained in jail for 2 years. Had he accepted in the very first hearing that he has committed the crime, so in the next hearing after 2 years when he went to the court, he accepted that yes, I have committed the crime. The maximum penalty is 6 months only, he will be released. If he does not accept, I mean till the time the trial concludes, he will have to be in jail. So that's the problem which is being faced in our judiciary, and obviously the common man is facing all these problems. So what are the reasons why we have so much of judicial pendency? Can you guess why we have so much of judicial pendency? A few reasons must come from you. Obviously, I will tell you. I watched this case in Crime Patrol episode. Okay, so there is someone else also who is a big fan of Crime Patrol like me. Inadequate infrastructure. Manoj is saying that there is inadequate infrastructure. Yes, you are right. And in particularly, the court system is still not adept with the digital infrastructure completely. A lot many things happens in paper format. Like if you ever, I mean, I don't wish that you ever have to go to the court. It is not a good thing to happen for right reason or wrong reason. But if you ever go to the court, you will always see files after files, and in the files something is being written indiscriminately. By the time the case comes to conclusion, the file is so thick. Okay, so vacancy in court, there are less number of judges. That is also a problem. Obviously, if judges are not there, who will do the justice? That's definitely a problem. So broadly speaking, we can categorize these problems into three categories. Okay, this is something that you must have seen. Tariq pe tariq. You do not get justice, you just get dates after dates in our courts. Okay, so broadly speaking, we can categorize these reasons in three different categories. One is that a lot many cases are going to the courts, and the second category you can say that courts are not able to dispose of those cases, not able to dispose of cases quickly. See, if the number of cases are also less, then probably there would be less pendency. So that's first thing is there are a lot many cases which are going there. And the second thing is that courts are also a bit slow, a bit lethargic. So they are also not able to dispose of these cases. So let's see why are the reasons why there are so many cases. First is that we have a lot many legislations. And also like in last class we have seen that there are delegated legislations, there are rules being made. So first we have integrated judiciary. The same judiciary is dealing with central law as well as the state law. So there are so many laws. Then there are rules made by the bureaucracy, and these are often very complex. Our legal system is very complex. It is often full of ambiguity. There are a lot of ambiguity in the laws. Okay, and add this to the judgments of the court. Like there are judgments of various high courts, which also high courts being court of record, high court and supreme court, they also act as a law. So they are often confusing, often contradictory to each other, because of which all the party thinks that they have something in their favor. If you go to the advocate, okay, the advocate will always cite you some reason or another that yes, you are right, because of various variety of so many judgments which are often confusing, contradictory as well. The next is that now the legal awareness among people has also increased. So people are also now more aware and they are approaching courts more often. And then this awareness has also resulted into more number of PIL and writ jurisdiction cases being filed in the court. Okay. Next is, there are few high courts which still have civil jurisdiction. These are basically the high courts of Bombay, Madras and Kolkata. So these high courts still have original jurisdiction. Civil jurisdiction, why I am saying that original jurisdiction in civil matter. Normally high courts are courts of appellate jurisdiction, but since these high courts are having original jurisdiction, a lot many cases are directly going to the high courts and these high courts are getting clogged. Okay, so high courts are not designed to deal with the original jurisdiction, original matters, because when original matters goes, you have to deal with the evidences, etc., all those things. But whereas when a matter goes into appeal, only argument happens fresh manner. No new evidences or no new what you say, gawah that you say, are allowed at the stage of appeal. I mean, only in the rarest instances in appeal these things are allowed. The court of appeal primarily deals with arguments based on the evidence that were presented, whether the court has been able to apply the law properly or not. Okay, so original cases takes a lot of time. That's why there are so many district courts and even municipal courts, etc., who deals with original jurisdiction, and there are limited number of high courts and supreme courts to deal with appellate jurisdiction. But if original cases are going to the high courts, they are going to clog the high courts. Okay. Next, we are going to see that in case, okay, one more, appeal against the tribunal. This is the last point that is also important, because after Chandra Kumar's judgment, you might be aware, otherwise we are going to discuss tribunal also today. After L. Chandra Kumar's judgment, what Supreme Court has said, that appeal against tribunal is also lying with high courts. So this is also burdening the high courts. Lots of holidays in court, less number of working days. Yeah, that is another problem with the higher judiciary. That is also, you can say, it is not the lower judiciary does not have so many holidays. Holidays are only in High Court and Supreme Court. Okay, so not able to dispose of cases quickly. We can say one reason is resource crunch. What is the resource crunch? So first is, we have less number of judges. We do not have adequate number of judges. This is also a reality. Okay, like judge to people ratio, total number of judges to people ratio. So we in India, for per million population, per 1 lakh population, we have 21 judges. We have 21 judges per million population. Whereas in USA, there are 107 judges per million population. In China, there are approximately 300 plus judges per million population. So you can see, if you compare with, simply like if you get a system like USA, the pendencies are going to be 1/5. Even if you just increase the number of judges, if you make it 5 times, they are able to dispose of 5 times number of cases. So if today the pendency, an average time taken is 10 years, probably it will go down to 2 years just by having adequate number of judges. Okay, and even like this is like the sanctioned strength. The sanctioned strength, whatever we have, there is a huge number of vacancy also. On an average, the vacancy of judges there are is approximately 30%. See, it varies from time to time, but on an average we see that at any point of time, this is about high courts. In high courts, 30% of the seats of judges are vacant. This is also a huge problem. If you do not, first there is a lot of pendency, and then you do not have adequate number of sanctioned strength, and even the sanctioned strength, one third is approximately vacant. Then the problem is not only because judges are, there is lack of judges. The problem is also because those judges are also involved in administrative work. Like the whole of administrative machinery, there are like HR management related issues, the establishment related issues, and all those things are also handled by judges only. So this also leads to a lot of delays. Then lack of use of ICT in case management. Still we are, our judicial system is using a lot of paperwork. There has not been complete digitization. Okay, although work is starting, digitization is happening, but still we are not at par with other departments like income tax. Income tax has done a wonderful job. A lot of things, or almost all the things, have been digitized over there. Okay, but the same is not happening here. Like RBI, they are also digitizing a lot of their work. Even my organization where I was working, it has started the process, but it has not completed. NABARD is also digitizing all its records. So when it is digitized, definitely things move faster. Otherwise, if you have to take a printout, then move it, send it to someone, then you are sending the letters, it all takes time. And the third is, there are certain external factors also that are leading to delays. For example, factors related to advocates. Advocates are also asking a lot of frequent adjournment. This is one of the biggest problem for delay of cases. And advocates are primarily, this is like most of the articles that are written in newspaper, they agree that advocates are primarily responsible for adjournment. For example, I mean, if you meet the advocate that what is going to happen in the next case, uh, advocate will say, we will get the adjournment. I can get adjournment like this. But your duty is not to get adjournment. Your duty is to get the justice. I mean, delay of justice is itself a denial of justice. So that is not supposedly the work of the advocate. Okay. Then there is problem with policing also. Like the policing, or whatever be the enforcement organizations, they do not do due diligence in their investigation. Like scientific investigation, etc., is mostly absent. Because the investigation is not proper, it also leads to a lot of delay. Okay, so these are all the factors which are there. You can add to the factor of here, like holidays, etc. Here in resource crunch part, you can add that holidays in higher judiciary. Definitely this is also one of the ideas, or other one of the reasons being stated, especially by the ministers of the government. But ministers are not happy, bureaucrats are not happy. We do not get holidays. Why should judges get holiday? It's logical, and this is definitely a British legacy. Supreme Court will talk of all the good things, but it will not talk of the things uh, that it has to improve, where it has to take the burden on itself. Supreme Court will talk about the electoral reforms, will talk about all the women rights and all those things. But when it comes to the court itself, the court will not, court remains silent. Obviously, there is a saying like, there is a line of Harivansh Rai Bachchan in Hindi that par updesh kusal bahutere. It's not line of Harivansh Rai Bachchan, probably it is from the Ramcharitmanas. That par updesh kusal bahutere. It's very easy to preach others, very difficult to implement the same thing on yourself. Next, we have to study that what are the impacts. Let's also understand that if delay is happening, obviously you all understand that delay is bad, but we got to write 6-7 points when the question comes. So let's compile it, that what are the negative consequences or ill effect of these judicial delays. Can you tell me? Please everyone mention 1 or 2 points. What's wrong? If if the judgment is coming, judgment is right, it may take time. What if if it is coming in 5 years or say 10 years? What's wrong with it? In cricket, it is said, let the run come as long as it comes. So why we are bothered that it should come early? Justice delayed is justice denied. Very good point. What else? See, one thing is obviously justice delayed is justice denied. You got to think of its political implication, its social implication, its economic implication as well. Under trial cases increases. Yes, you are right. There's some the number of under trials are very high in our court. 75%, the data I have given, 75% of prisoners in our courts are under trial. Whenever you write this is the data that you must write. Next is there is judicial evasion also. Judicial, what is this term? Judicial evasion. So as it says, when there are too many cases pending with you, then obviously judiciary get to pick and choose which case to handle and which case not to handle. So invariably the more significant, more complex cases are left behind and silly matters are dealt on priority. For example, this case, industrial alcohol case, it was there. This is the case that involves judicial interpretation or constitutional interpretation. It should have been given priority. That is the primary duty of Supreme Court. At least what people see. This is the court. Supreme Court has been given the responsibility of interpretation of Constitution. There is no other court which does this, and that is something which is taking for around 14 years. So similarly, a few months ago, there was also a case which dealt with the state's right to uh, tax minerals, the land from where mineral exploitation is happening. That case also was filed in 2011 and then judgment came in 2024. So leave the important but difficult cases hanging. Even like Ayodhya dispute, which was pending for around 7 decades. After 7 decades, the finality of this case came. Next is there is economic impact involved as well. What's happening? It drains resources of the litigants. When the case is hanging for so long, there are so many adjournments, etc. And especially the matters in which some contract enforcement is involved. If contract is not enforced, it is leading to economic loss to the parties involved. Whichever party which is trying to enforce the contract, because of the lack of enforcement, there is definite economic loss. Then justice seeking itself become a punishment, so people avoid justice. People have a tendency to avoid the courts, and in this process what is happening, that the credibility or loss or faith in the judicial system is getting eroded. Again, then you see those movies being made where people are criticizing of the judicial system, that we do not get, and people keep a demand for instant justice or the demand for like encounter killing. It encourages, because there is delay in dispensation of justice. So these are the problems which are there. So the problem are, first is it is denial of justice itself, and see, justice is one of the fundamental right of the people. Supreme Court has said that to get justice is the fundamental right of the people, and also it is the objective of our constitution. So that objective of our constitution is defined. Then we will talk of from the judiciary perspective, that judiciary also leads to evasion of the cases. From economic perspective we will deal. Then from so this is also a point that it is leading to lack of ease of doing business. When you are not able to enforce the contract, it means the other people, it will the other companies from FDI or foreign companies will not trust the Indian judicial system. So it would also reduce investment. Before doing business in India, the companies will think twice. Until unless they get very good remuneration, very good profit, they would not be willing to invest in India, because the marginal profit, like they might invest in USA on marginal profit, because they are at least sure that this marginal profit will come to them. But in India, they have to discount that some of the contract may not be obliged. So there could be some unaccounted losses also that we are not able to predict right now. Okay, anyway, like the CEOs of global MNCs have accepted in a survey that there is a cost to corruption in India. So when they do calculate in their investment decision, they do encounter this cost as well. Okay. So how we can deal with this problem? What are your suggestions? One suggestion, obviously, I understand that reduce the number of leaves which the judges of High Court and Supreme Court are getting. I understand if students are not getting, we are doing the UPSC preparation day and night. Why should judges have the fun? What else can you suggest? So when we have to do this, give the suggestions, again we will think of the same three ways, same three direction. That first, do something that will reduce the number of cases going to the courts. Second, make the courts efficient so that cases are disposed of quickly. And here, to the reform would not limit to courts only, because the problem are outside court also. Yes, you are right. So first thing is that do something that will reduce the number of cases coming to the Supreme Court. Like one idea is that Supreme Court should take less number of cases. Supreme Court should mostly deal with the cases which involves interpretation of law or interpretation of constitution. It should not currently, as we have seen in the last class, the writ jurisdiction is only 1.8% of total cases. Most of the cases are under appellate jurisdiction, and those are the cases which have already been in appeal once, they have been reviewed by the High Court once. So even after that, Supreme Court should be very cautious and very choosy in taking cases. Okay. And more often, it is also being said the Supreme Court should have more judgment, or rather more authoritative judgment by higher benches, or rather larger benches. See, all the judgment given by Supreme Court acts as a precedent for the high courts and lower courts. So if Supreme Court delivers more of the judgments which are in the nature of interpretation of law, it will settle various legal contradictions which are there because of the different judgment given by different high courts. So Supreme Court should rather focus on this, and obviously the judgment given by the larger bench will have precedence. So whenever there is any conflict, etc., the conflict of law, addressing the conflict of law should be the major point of major focus area for Supreme Court. Okay, and here there is also this idea which Manoj is talking of, that we should have regional benches of Supreme Court, or rather which is often called as, we should split Supreme Court into Court of Appeal and Supreme Court, Constitutional Court. So Court of Appeal should deal with appellate matters, and Constitutional Court should deal with constitutional matter where interpretation of constitution is involved. Okay, next is that the laws should have sunset clause in its legislation. We have discussed it in studies that sunset clause means until it is reviewed, updated, after a particular date, the law will lapse. So the ambiguity between various laws will go. Irrelevant laws will not be there in a statute book. Then we should promote alternate dispute redressal mechanisms. We are going to cover all these things in regional benches also, we shall cover in today's class itself. ADR also we are going to cover. If there are a lot of issues solved through arbitration, mediation, lok adalat, family courts, etc., then the court would be unburdened. So out of court settlement should be encouraged. Then there should be a system of plea bargaining. This is something which is followed in USA. Plea bargaining is that someone who is accused, he can accept his guilt rather than going into the trial, etc. He can accept the guilt, and in return the government can reduce his punishment. Okay, so often, like if you have seen US TV series, etc., you will see that the attorney over there or the public prosecutor enters into plea bargaining with the accused, and accused, say suppose the possibility of sentencing is of 10 years, the accused will say that okay, I will accept my crime, and in return I will only get punishment of 5 years of imprisonment. So when accused says that there is a watertight case against me, I am definitely going to be imprisoned, convicted, in that case he will go for plea bargaining in return, and this is like win-win situation. The court also does not have to uh, go through the rigorous, etc. This will reduce the number of cases. Okay. The other ideas that people are giving is uh, tribunal court for special cases like contract, land acquisition, IT, etc. This is something that is already happening. No, it's not like sarkari gawah per se, but yeah, to some extent. But India as such does not have this complete system of plea bargaining. Uh, in India, this is only a very partial in nature. Like suppose you have to implicate someone else, you become the approver. Okay, in plea bargaining, you could be the only accused involved. You need not have to implicate anyone else. Then also, it is the purpose of plea bargain. India simply has a system that you cannot self incriminate against yourself. Here the system is saying that yes, you can self incriminate yourself. You can go to the court and say that I have done the crime. So the court will not go into the detail that whether you have done the crime or not. Simply say that you have accepted. Court will say that okay, what is the crime that you have agreed. So public prosecutor will say that we have agreed that only 3 years imprisonment would be given. Okay, done. 3 years imprisonment. Obviously, they have norms. What is the minimum? What is the maximum? How much is the exemption that can be given? They have detailed procedure. Similar kind of system we can bring. It was suggestion that in the revamped IPC, we should have brought this system of plea bargaining. Okay. Next, like we should augment our resources also. Like there is less number of judges. So one idea is that why not have all India judicial service? And apart from that, there is one also reason I have read in a lot many articles that people are saying that there are few judges especially in the lower judiciary, this is something happen. The new judges, the magistrate, etc., which do not feel confident about the legal nitty-gritty, etc. They, rather than deciding the cases, they also very conveniently adjourn the matters. Okay, so probably there is also the issue of competency of judges in fewer states. Okay, so here also this idea of all India judicial service is very much helpful, because if there is an all India recruitment from the all India level, it will have two benefits. One is the recruitment at all India level, so there is wider catchment area for recruitment, better talent would be attracted to judiciary, and the next thing would be that there can be training by the central government. So the way it happens for the IAS officers, that they are recruited and trained by the central government, the same mechanism can be followed for judicial officers also, and it can improve the quality of judges in lower judiciary. Okay. Next is the idea of NJSC. NJSC also can address the vacancy in high courts. Currently, the see what is happening. The same judges which are having the responsibility of delivering justice in the Supreme Court, they are also having the responsibility of finding the suitable candidate. They do not have a separate secretariat either for the collegium. So in case we make a dedicated body which is involved in appointment of the judges, probably this body can do the timely recruitment. Okay. Next idea is that the judges should not be involved in administrative work. For that, we should have professional court managers. Like the way there are hotel managers who professionally manage the hotels, businessmen, various businesses. Similarly, now the courts are very big in size. There are a lot. They are handling a lot many cases, and now there is a requirement. The time has come that we have professional managers for managing the administrative work of the courts. Okay. Next is relatively easy. See, BNSS already talks of all the good things that is required. It gives the time limit. We have already seen this when we were studying the fundamental right chapter. There we have seen that BNSS prescribes time limit for filing charge sheet, time limit for hearing, time limit for uh, this delivering judgment. So it has prescribed time limit, we just need to implement it. It also mentions a provision that there would be mandatory forensic investigation in cases where penalty involved is more than 5 years. Okay, so since it is talking of already mandatory forensic investigation, it is definitely going to help the disposal of justice. It's just that it has to be implemented. We got to create that kind of infrastructure. Okay. Next is this is an idea that there should be cost payment for adjournment, and this is something which has been advocated by Supreme Court itself in one of its judgment. So the idea is simply that if one of the parties involved in the case is requesting adjournment, he should pay to the other party the cost involved. Like, see, other party has brought his uh, documents, etc. That party might have traveled all the way from some corner in this country. There is the fee of advocates involved, and a lot many costs might be involved. So the party which is requesting for adjournment, because see, a lot many times adjournment is given because, say, my father has fallen sick, so I cannot come to the court, please give me adjournment. Court very routinely give adjournment, and this is called as adjournment due to convenience of either of the party. So, in case one party is seeking adjournment, he should pay cost to the other party. This will deter the parties involved in a dispute from asking adjournment. Okay. So when you are giving this problem, solving this problem of adjournment, you have to think of all the three levels of judiciary: lower courts, high court, and supreme court. The problem or the solution will lie in all these courts, and if you mention points, and the points has to be in all these three category. How the cases itself are stopped from coming to the court, obviously legal ways and not illegal ways. How we can make the court more efficient, how we can make other stakeholders more efficient and accountable. If you think in all this direction, you will definitely have a comprehensive answer to a questions, any question related to judiciary, particular judicial delays. If you have any doubt, please ask. Any doubt with respect to any of the points? Otherwise, please mention all clear, sir. Okay. So next topic that I'm going to deal is regional benches of Supreme Court. One of the ideas that we just discussed, we should have regional benches of Supreme Court, and this is also called as another, the same idea is often written as Court of Appeal or Court of Cassation. Court of Appeal or Court of Cassation. Cassation is the word that is coming from French judicial system. Court of Appeal is the word that is coming from US judicial system. So this is not an idea which is original to India. This is an idea which is coming from USA. This is an idea which is already in practice in other countries, like South Africa also has circuit court kind of system. The similar system is there in France as well. Okay, so let's see what the idea is first. As the image is being portraying, currently we have one Supreme Court, that is in Delhi. So the idea is simply that let's have various branches of Supreme Court. Like this is the system which is already being followed in few states by high courts. For example, in UP, the principal bench of the high court is in Allahabad. But then we also have a Lucknow bench of the high court. The similar mechanism is also followed in Madhya Pradesh. There are multiple benches of various high courts. So why can't we have the similar system for Supreme Court? And this was in news because there is a parliamentary standing committee on personnel, public grievance, law and justice. If it is difficult to remember the full name, you can simply remember that one of the parliamentary standing committees has informed the parliament that the law ministry has approved the committee's suggestion to establish regional benches of the Supreme Court. So, Law Ministry has agreed to this suggestion. But well, if you simply look at the Article 113 in our Constitution, this article is about the seat of the Supreme Court, says the Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of President, from time to time appoint. So it would be decided by Chief Justice of India CJI with the prior approval of the President. So probably what we can say that President has given his approval, but it is not clear if approval was sought by CJI. So it seems that the government is agreeable, but from the various statements etc. of the Supreme Court, it seems that Supreme Court is not agreeable to this idea. So we shall see what are the arguments in favor of this idea and what are the arguments against this idea. Okay, it is a question can be asked in prelims. The seat of the Supreme Court can be outside Delhi, yes, but who will decide? It will be decided by CGI with prior approval of President. Okay. Now the next thing is that what is the argument in favor, or why are we saying that there should be regional benches, or if the question is what are the benefits for having regional benches of Supreme Court, and one of the ideas you have just said, it will reduce the number of cases. So the idea is simple. Let's discuss it with the first ideas completely. The idea is simple, that there should be one principal bench, or which can be called as constitutional court. So divide Supreme Court into a constitutional court which will sit in Delhi, and court of appeal, or other four court of appeal in four corners of the country. So rather than having one Supreme Court, we will have one constitutional court which would be stationed in Delhi, and four court of appeal or court of cassation in, or which is called as regional benches, in four different corner of the country. This will deal with original jurisdiction. All the matters related to original jurisdiction will be dealt, all other the matters involving constitutional issues, constitutional interpretation, okay, will be dealt here in constitutional court, whereas the matters involving appellate jurisdiction would be dealt in court of appeal. This is broadly, I mean, obviously there are various other matters also. Special leave petition is also involved. There are matters with respect to writ jurisdiction is also involved. So we can decide which will deal with which, but the broader contour is this, that appellate matter would be dealt by this court of appeal, and constitutional interpretation matter, original jurisdiction, will go to the principal bench. Okay. Now, what going to be the benefit? The benefit first is that Article 39A says that there should be equal justice and free legal aid. Now, this system will make justice more accessible. In fact, there are data to suggest that as of now, justice is not accessible. Why? Because there is geographical bias in the number of cases being handled by Supreme Court. Nearly 1/5, 20% of the appeal from Punjab and Haryana. These are the two states which comprise 50%, sorry, 20% of the cases, and then further 10% are coming from Delhi. So these three, Delhi, Punjab, Haryana, they all together comprise approximately 1/3 of the total cases in Supreme Court. And in fact, the states like Odisha, there are less than 3% cases from Odisha. Jammu and Kashmir, Assam, there are less than 1% cases which are coming from Jammu and Kashmir, Assam, these regions. So definitely there is a geographical bias. And why is this bias? Because there is a travel cost and time constraint for those litigants which are residing away from Delhi. Okay. Then it will also reduce the caseload, especially on the constitutional court. And when we will have multiple courts, then there would be also reduction in delay. You can say that it would lead to a speedy justice. Then currently it is not that there is a geographical bias only in uh, litigants. Among advocates also there is a geographical bias. Most of the advocates practicing in the Supreme Court, belong to these states only, Punjab, Haryana and Delhi. So in case regional benches are there, there would be advocates from those regions also, which will practice in the courts, in the Supreme Court. It would lead to diverse perspective, which will enrich the justice system of our country as well. Okay, and this is also a practice, as we have said. In USA there are 13 branches of USA Supreme Court. In Brazil also there are 5. In South Africa also we have circuit hearing. There is similar arrangement also in France. So globally also this is the best practice which is followed. So probably it has a lot of advantage. We should go with it. On an average, constitutional matters, on average time taken by constitutional matters is 8.5 years. Any case which is referred to a constitutional bench, it takes on an average 8.5. We have seen example today that a case was there for 14 years. Obviously a few cases have been like the case of involving electoral bond. It took only 5 years. So if it is, you can say, if it was a judgment was delivered on something within 5 years, we are saying it took only 5 years. See the beauty of this thing. Okay, so this is the reason why we are saying that probably there is a need for judicial regional benches of Supreme Court. Just give me a minute, there is some problem with my laptop. Next is, the court is not agreeable. In Supreme Court, judges have on various occasions mentioned that this is not a good idea. Probably because of their resistance only, as of now, we do not have regional benches, because the government is ready. Once Supreme Court is ready, it would be implemented. Why is Supreme Court not ready? And the reason is, it believes that there is going to be inconsistencies in legal interpretation. Like currently we have one Supreme Court. Later on what we will have, 5 different branch, 4 branches and 1 constitutional court. So there will be 5 different centers from where judgment would be pronounced. It can lead to inconsistency or in legal interpretation. Next argument that is given is that it will also, another argument which is given, that it will erode the credibility of Supreme Court. When Supreme Court has various branches, now currently there is one Supreme Court, its authority is ensured. Now when there would be various branches of the Supreme Court, then the credibility would go down. And another argument which is given by the Supreme Court is that, this is the argument which is given, probably it would require the constitutional amendment. And why I am saying is that Supreme Court has said that the in fact there was a presidential reference to the Supreme Court. Am I audible? Is this video running or it has paused? Please confirm if video is coming properly. Please confirm if video is coming properly. Okay. So the debate is about, there is a need for constitutional amendment. Why? Because Supreme Court has said once that the Constitution provides for singular Supreme Court. That there should be one Supreme Court, and the singular Supreme Court means that there should be one Supreme Court that should be dealing with constitutional matter as well as it should be acting as an appellate court. Or you can say that there should be one single court having writ jurisdiction, appellate jurisdiction, original jurisdiction, and dealing with constitutional interpretation. Okay. So the idea which is given by the Supreme Court is that the Constitution prescribes a singular Supreme Court which would be dealing with all the matters, whether it is original jurisdiction, appellate jurisdiction, or writ jurisdiction. So from there, people are saying that probably under the current circumstances, we cannot implement it simply. The article that we have just seen, it says that the seat of Supreme Court can be at some other places, but it doesn't say that there can be different branches of the Supreme Court. Okay, and then there people are also afraid that if this constitutional amendment would violate the basic structure or not. It is not yet clear that it will violate basic structure or not. Only once the constitutional amendment is done, we will come to know that it violates basic structure. And obviously, setting up the new benches would be involving the financial resource burden on the government. It would also create some logistical challenges. It would also create the issue of coordination. And it is also argued that it may undermine the authority of the high courts which are situated there. If there is also a Supreme Court, people will have tendency to approach the Supreme Courts. Then it may also lead to more cases under appellate jurisdiction. Suppose it is more accessible, like people in these days, people from Bhubaneswar, they are not filing appeal against the judgment, High Court of Odisha or Bhubaneswar High Court judgment. Now they will have more tendency to go for appellate jurisdiction to the Supreme Court. It will further burden, rather than the idea being unburdening the Supreme Court, it can further burden the Supreme Court even more. Okay, and there is need to reform the lower judiciary. The problem of judicial delay is in lower judiciary because the quality of judgment delivered by the lower judiciary is not sound. That's why more people are going in appeal to the higher courts or high courts or Supreme Court. Okay, and also one other argument which is being given these days is that in COVID-19, like after COVID-19, the Supreme Court has allowed uh, trial, or rather trial through video conferencing. So now that trial through video conferencing is allowed, the justice has already become accessible. So probably the need to have regional benches is no more felt. But you know that all these regions can be countered. None of these are very substantive in itself. For example, inconsistencies in legal interpretation. We already have so many high courts which are court of record, which are dealing with all the central laws as well. They are not leading to any inconsistency in legal interpretation. If we are having that kind of system, why can't we have four benches of appellate jurisdiction? And then the matter which would require the constitutional interpretation would be dealt by one central constitutional court only. It is not the regional benches are not going to deal with the constitutional interpretation related matter. Okay. Then similarly, obviously, financial and logistical challenges, again in the era of ICT, the logistical challenges can be very easily dealt with. The financial crunch is definitely not going to be much. We are already maintaining various high court. We can also maintain one regional bench over there. Then it will not undermine the authority of high courts, because high courts have different jurisdiction. The appellate court will have different jurisdiction. Like in Delhi, high court jurisdiction is not undermined because of the fact that in Delhi there is a Supreme Court. So if Delhi High Court is not undermined, other high courts will also not be undermined. And the debate about constitutional amendment, if it is required, we can have it. We have already gone for 105 constitutional amendment. There can be one more. That's not an issue. But yes, you have to write all these points in the end. You have to see, this is this is something that I have been saying to you since beginning. In case a new idea is proposed, until unless it is completely arbitrary, irrational, you have to support the idea. So you have to support that yes, we can go anyway. Currently, the government is favoring, as informed by the parliamentary committee, law ministry is in favor of this idea. So our conclusion should also be in favor of having regional benches. We should say that probably it would require the constitutional amendment. So we should follow the due process. We should consult the Supreme Court. By taking all the stakeholders into confidence, we should implement this idea. Is it clear? Please say if it is clear. Okay, so next, that's all about this regional benches. Next, we are going to discuss alternate how to reform lower courts. See, how to reform lower courts will involve, like, one idea is All India Judicial Service. That is something that can be implemented. Then the idea is about digitization, that make all the processes etc. digital. All the data, all the documents that they are handling, everything should be digitized. Then there should be case management softwares that should be used for automatic allocation of time dates. So the discretion that is there with the judges currently, that which case to be given priority, which case should not be given priority, when to allow adjournment, these discretion are also leading to a lot of delays. So this should be taken away, and probably there should be some automatic system. Only in the rarest of the rare cases, the discretion should be there that the system is allowed to be bypassed. And then the one idea that we have discussed, that there should be a adjournment cost to be imposed. In case there is any adjournment, we can have the adjournment cost. There is also lack of infrastructure related issue. A lot many, like if you read the local newspaper etc., there are always this debate that the enough space is not there in the court premises. So that enough space should be created. More number of judges should be there. And then we should have professional court managers. So the various ideas that we have discussed, they are applicable in the lower courts also. Is it clear? Have we got the 5 points? Professional court manager is also a point which is applicable in the lower courts also. What is fast track court? See, fast track court are established for a specific purposes to fast track some of the cases. Okay, for example, to deal with the crime against women, if a fast track court is established in Delhi, so that court would deal only with one issue, that is crime against women. And then this court usually hears matter or like conduct the trials on day-to-day basis. So normally what happens that today one evidence has been introduced in the court, one witness has come to the court, then on the next date, that can be after 2 months or 3 months, because the same court is dealing with a lot many cases, a lot many different cases, the cases related to corruption, the cases related to murder, dacoity, loot, uh, crime against women, crime against scheduled caste, various different kind of crimes, all cases are going to the same court, because of which once your matter is dealt, the next date you get is usually of few months later. In fast track court, what happens that the matter is heard on day to day basis. So every day, like first witness is examined today, second witness will be examined tomorrow, and the process will continue till the time the trial is completed. So because of this reason, the what you say, the judicial process is expedited. That's why the name fast track court, because it gives justice very fast. Maybe like what this is how judicial system works. It does not work the way we see in the movies. Practically what happens that first police or any investigative agency, it completes the investigation. So it records all the witnesses, it records all the evidences, everything is prepared, then it files the charge sheet. Okay, so already police knows that which are the witnesses that I have to present in the court. Now the delay happens because the court is indulged with a lot many cases. Okay, so and also like same advocate is also sometimes involved in a lot many cases. The advocates which are famous, they take up a lot many cases, and because of that reason, sometimes they are not available on the same day. They have multiple cases, so that's why they do not appear and they ask for adjournment. So in case in fast track court, what happens? Every day you are given opportunity. So whatever days it takes, if there are 15 witnesses, 20 witnesses, 50 witnesses, maybe 50 days it will take. And then once the trial is completed within 30 days or 60 days, the judgment would be pronounced. So that's how the justice is delivered in a fast track manner. From there the term fast track court has come. So when a specific issue comes like criminalization of politics, there we will give this recommendation that we should have fast track courts dealing with MPs and MLAs, because we cannot have criminal people sitting in our legislature. So if uh, their matters should be expeditiously dealt. Suppose they are not criminal, they would be released, then we would not have any criminal in the court, in our legislature. Suppose they are actually criminal, probably they will become disqualified and they will not be sitting in our legislature. So in these cases, like when there would be question on crime against women, then we will give the suggestion there should be more fast track court for crime against women. When there is a question on corruption, then we will say that there should be fast track court for dealing with matters related to corruption. Is it clear, Manoj? Next topic is alternate dispute redressal mechanism. Okay, there are various ways in which alternate. Why we are saying alternate? Because see, we have three-tier court system, judicial system, where there are courts, lower courts, which are also known as subordinate courts, usually at the district level. Then we have high courts, and then we have Supreme Court. So these courts, they follow the code for CRPC. Now we have VNSS and Civil Procedure Code. Sorry, Code for Civil Procedure. Then they follow the Evidence Act. So there are laws or procedure which are mentioned, the codes which are mentioned which are followed in these courts, they are manned by judges. So this is what we call as normal ordinary judicial court. If we are able to sort out matters outside this ordinary judicial court system, then we call that as alternate dispute redressal mechanism. Alternate, this is alternate to the ordinary judicial court. For example, family courts. In the name, they are given as family courts. In fact, they have been established by Family Courts Act 1984. This is the year. This is the year in which Mrs. Indira Gandhi was assassinated. So, through Family Courts Act 1984, family courts have been established, and the family courts, they deal with marriage related, matrimonial related matter, marriage, divorce, etc., custody of the child. So, see, when two people have gone against each other, and when in this system lawyers get involved, they often keep on fighting, and it is felt that in matrimonial disputes probably the agenda should not be to fight out each other, rather somehow the differences should be mitigated. So in the family court, the first effort done is to do some kind of mediation, so that the both parties which are fighting with each other, they should sort out their differences, and the matter need not be dealt in a court. But in case the mediation fails, there is no reconciliation between the two parties, between husband and wife, then the matter is dealt in the same manner as it would have been dealt in an ordinary judicial court. So the only difference with the family court and ordinary judicial court is that family court, it first thing is it deals with the matrimonial matters only, and the second, it first attempts to do mediation so that there is a compromise, there is reconciliation between the two parties, so that the matter does not so that there is no requirement of judicial proceeding. Suppose husband and wife, one party is saying, wife is saying that I want divorce. Somehow we are able to persuade the wife that okay, there is no need for divorce. Sometimes people make mistake, there might be some confusion. So there are counselors in these courts who counsel on the matrimonial matters, and their agenda is that somehow both parties should agree, make a compromise. Okay, so the families are protected. Their agenda is to protect the family. In case it is not possible, suppose with the effect of the counsel or the mediation fails, the two parties are still adamant that no, 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 now we cannot live together. Enough is enough. Okay, in that case, they will go to the, then the matter would be dealt, just it would have been dealt in an ordinary judicial court. The same civil process, CPC would be followed, Evidence Act would be followed, whatever is the law of like Hindu uh, Marriage Act would be applied, and then all those procedure would be followed. Next, we have Gram Nyayalaya. These are the courts which are at the block level. Okay, so it was established through Gram Nyayalaya Act 2008. So neither family court, not Gram Nyayalaya, and like the third we have Lok Adalat. None of these are constitutional courts. The constitution does not mention about them. Okay, so this is an intermediate panchayat level, that is block level, and usually there is a Nyayadhikari which is appointed by the state government, which deals with this matter. So this is simply an extension of the subordinate courts. The way subordinate courts would have functioned, but since subordinate courts are there in the district, they are at the block level. subordinate courts have constitutional backing. These courts have been established by the law of an act of the parliament, and then there have been only a specific civil and criminal cases that can be dealt. So these are the cases which are listed in the statute of the Gram Nyaya Act. These cases are only dealt, so not usually the grievous matter, the matters related to murder etc., they are dealt in the district court in itself, but relatively less serious crimes which are not so serious, or even the civil matter, they are dealt by these Gram Nyaya. Okay, so these are simply like fourth tier, local self-government. So at the block level also we have courts to make justice more accessible. Next we have Lok Adalat. This is something which is different from these courts. Okay, Lok Adalat has been established, I mean it has been given legal backing through Legal Services Authority Act. Legal Services Authority Act 1987. So through this act, Lok Adalat has been given statutory recognition. And see, Lok Adalat, how it works. Lok Adalat also, the very principle of Lok Adalat is to reach a settlement, which is also called as compromise. The basic philosophy is that most of the cases which are pending in the courts, they are not so serious that you remain in court for years. Suppose I have taken a loan of say 60,000 from bank, and probably even with the 10% interest rate, the total amount due is 66,000, 70,000, it may be 80,000 few years later. But to recover this 80,000 money, the money to be spent on advocate is going to be more than that. If the matters drag, because the court cannot give judgment that someone has made a fault, the other person can give his argument that the bank has defaulted, or other I should have got some exemption. Other person can say that I have become bankrupt, I do not have the means, then the bankruptcy proceeding will start. In all this process, if there is more than 10 or 20 uh, sittings of the court, the cost involved to the bank is going to be more than the money involved. So probably it is better that both of these parties come to a compromise. The outstanding amount that now bank is claiming that because 10% interest, you have taken 60,000, now you have to pay 1,50,000. The other person is thinking that I had taken only 60,000, the bank is asking 1,50,000. Now if the bank makes an offer that okay, you pay 70,000 and we will remove the matter, or suppose 80,000 or 90,000 you pay that, bank is ready to take a hit, that person would be more than happy to okay, pay the 90,000 amount and get rid of all these proceeding, legal proceeding etc. So such small petty matters which can be compromised outside the court, they are, for that purpose Lok Adalat has been established. The beauty of the Lok Adalat is that here, like, it is not in the ordinary courts. In the premises of the ordinary courts, Lok Adalats are organized. The date is usually announced that on this particular date, we are going to organize a Lok Adalat, and there are a lot of serving judges, retired judges, lawyers, social workers. They are engaged, and these people try to help the litigants reach a settlement. So they do not pronounce a judgment. This is the one thing that you need to understand. They do not pronounce. You may write it down. In Lok Adalat, the effort is made to reach a settlement. The judges, the legal worker, the social worker involved in Lok Adalat, they do not pronounce judgment. Okay. they simply help the parties that okay, if you do this, it's like that friend, two brothers are fighting, they can go to the father, and then the father can sit and say that okay, so you are saying that you should get this much money, he is saying that you do not deserve this much of money, probably why don't you split the difference, why don't you follow the middle path, something like that. That is the approach adopted in Lok Adalat. Obviously, since it is involving compromise, it only deals with matter that can be compromised outside court. So it deals with both civil and criminal matter, but only those matters that are compoundable in nature. Compoundable offenses, you must have heard it. Compoundable offenses are those offenses in which out of court settlement can be done by between two parties. There are certain offenses which are non-compoundable. Most of the serious offenses are non-compoundable. For example, rape, murder. It cannot be compromised theoretically. So suppose someone had murdered someone. It cannot happen that I give 2 lakh rupees or 1 crore rupee to that person and his brother has taken the case back, and now the person who has committed the crime will go scot free. Theoretically, this is a crime against the state and it cannot be compromised. Police is supposed to pursue the matter and bring justice. Practically, it does not happen. Practically, time and again, people take the matter back, like even the cases of rape, etc. Practically, there are instances where compromise occurs. The rape accused or the rape victim, very often she takes her complaint back. But theoretically, rape, murder, these are the offenses which are serious in nature. They cannot, no compromise can be reached outside court. Okay, but petty offenses like uh, suppose electricity bills, you have got electricity bills of 1 lakh rupees. You are wondering that last month it was 4,000 rupees. This month it is 1 lakh rupees. How come? So you do not pay electricity bill. Now next month also you have got the bill of say 10,000, next month 4,000. But since you have not cleared the due of 1 lakh rupees, you are not paying any of these electricity bills. After 3, 4, 5 months, your electricity connection is cut. Now you have filed a court case against the electricity company, or electricity company might file a case against you. If you know that 1 lakh rupee bill is not proper, probably electricity company also knows that 1 lakh bill is something, there is some fault. But to prove the same in the court that who is at fault, whether electricity company is at fault or whether you are at fault, probably it would take ages in a court of law. So why not go into the Lok Adalat and settle the matter that okay, not 1 lakh rupees, but I will pay you 10,000 rupees, which is the bill I have been getting every month. Electricity company can also settle the matter. So such offenses, offenses of traffic violations, offenses of electricity, utility bills, these are sorted out in Lok Adalat. Okay, then there is another thing which is also which involves in which is also a mechanism of ADR, is called arbitration tribunal. In fact, arbitration and mediation are the two items which are two terms which are often used simultaneously. I am not saying interchangeably. I am saying simultaneously. They are hyphenated with each other. But there is a large difference between mediation and arbitration. In case of arbitration, or this is arbitration tribunals, that is the word which is used. Uh, Manoj has a doubt that can a ordinary court, lower court refer a, it is not pretty, pretty means beautiful, it is pity, petty, a small, can refer a petty case to Lok Adalat. Answer is no. It is not the court that refers a matter to Lok Adalat. It is the litigants who can voluntarily take the matter to Lok Adalat. So if I am fighting with my brother, me and my brother can decide that okay, rather than fighting in the court, let's go to the Lok Adalat and make a compromise. And it is also possible that we voluntarily decided to go to the Lok Adalat, and there we could not reach any compromise. Then we will come back to the ordinary court and we will continue our fight in the court. Okay. And one more thing is, since we are voluntarily going to the Lok Adalat and we are on our own will, no judgment was given, on our own will we have decided to make a compromise. From the judgment of the Lok Adalat, no appeal lies to any court in India. Once it's, I mean, what happens that in front of those member who are the judicial member, who are like social worker, etc., usually 3-4 people sit there. I have been once in the Lok Adalat. Okay. So regarding like uh, my uncle was having this Kisan credit card and he was not able to pay the loan. So bank and my uncle, they reached the Lok Adalat to make a compromise. So I had accompanied him. So there 3-4 people would be sitting. One of them would be advocate, one of them might be some prosecutor, or anyone could be. One could be social worker. So in front of them, the bank manager and you will argue that okay, 1,20,000 is the due, pay the 90,000. Bank manager will say that I have got only authority to uh, remove 40% of your loan. So then we came to a compromise that okay, 40% is waived off. Out of 1,20,000, 72,000 is something that we are going to pay. So there, then we both party will agree on that number. On that agreement, all those people, the Lok Adalat, they will sign, they will become like a witness that yes, these two people have agreed to make a compromise, and then they will issue a judgment. So as a judgment is based on the agreement between the two party only. They just help you to sort out your agreement. They do not, like judges, they do not pronounce judgment. Okay, but once the judgment or the order is issued by the Lok Adalat, then you cannot file an appeal against that order. That is implemented. Okay. Next thing is arbitration tribunal. What happens that this is a kind of quasi-judicial mechanism. Okay, it is dealt by Arbitration and Conciliation Act 1996. And here also people go voluntarily only, that rather than settling a matter in the court, let's go to a arbitration tribunal. So it is like same thing, it has all the similarity with judicial system. Whoever is the arbitrator here, the person who sits in the tribunal who will give the judgment is known as arbitrator rather than judge. So arbitrator will give a judgment only. So he will listen to the matters from both the sides, and after listening to the matter, he will give his judgment only. But the only difference is that he is not bound by the Civil Procedure Code or Criminal Procedure Code or Evidence Act. He can decide his own mechanism of how to deal, but obviously he is bound by the law. His duty is also to implement the law. So it's simply that two parties are voluntarily deciding that rather than going to the expensive mechanism of courts, why don't go to a expert? It's like Mukesh Ambani and Anil Ambani, they are fighting. So the other than they could have gone to the court, they can decide that okay, why not go to our mother who is also aware of all the businesses handling, etc. And then my mother will act as a arbitration tribunal. But mother is family matter. Sometimes they can decide that okay, there are some business experts. There is a BCG, Boston Consultancy Group, or there are some World Bank. Maybe they can go to the World Bank. Okay, and there is a wing of World Bank known as ICSID, International Center for Settlement of International Center for Settlement of Investment. This is investment. International Center for Settlement of Investment Dispute. This is part of World Bank Group. This center is involved in arbitration activities. So in case there is a company which has brought about FDI and there is a dispute with some other company, some other country, these disputes are addressed by them. So rather than going to the ordinary court, because it very often it happens that the foreign company which is coming to India, they might have like the Indian courts will be a little bit biased towards the Indian government or Indian companies. So they prefer that why not go to the international arbitration. And also Indian courts would be time consuming, cost consuming. Cost is there also involved, but time is relatively less. In arbitration, your matter are dealt expeditiously. So all the arbitrators are appointed based on the agreement between the two parties. Two party agree that okay, we can appoint this person as arbitrators. The judgment here is also like binding on both the parties. The it's like same like a court judgment. It has the same effect. It is implemented. So normally, the cases civil matters where there is a commercial contract there or there is a property dispute. In those cases, this arbitration proceeding is used. So usually businesses engage in arbitration proceedings. Okay. No criminal, as per this Arbitration Conciliation Act, no criminal case can be dealt in an arbitration tribunal. It can only deal with civil matters, but not all civil matters either. Okay. This act provides that certain type of civil matters can only be dealt in an arbitration tribunal. It is not that all civil matters and no criminal matter can be dealt. Whereas, like this was a question in this year's UPSC paper, what is the difference between arbitration tribunal and lok adalat? First, we have seen that it is coming from Arbitration Conciliation Act, it is coming from Legal Services Authority Act. In case of civil cases, mostly the contractual or commercial matters. See, wherever a matter involves public interest, that matter cannot be dealt in an arbitration. Only matters having personal interest that can be dealt. The term that's in Supreme Court has defined that right against or right in personam. It means that right against a person. In that case, arbitration, you can go for arbitration. But in case there is a right in rem, there is right in rem. It means right against the world. Wherever there is a right against the world involved, I mean where there is a matter of public interest involved, in that case you cannot go for arbitration. Even the matters related to labor laws, you cannot go for arbitration. Labor laws like employment related matters, even to a lot many matrimonial related disputes, it cannot be. Like consumer disputes. Consumer disputes are also a matter that involves public interest. So this can also be can't be dealt in arbitration tribunal. Okay. Whereas Lok Adalat can deal with all compoundable matters. Anything that can be compromised outside court, that is allowed to be dealt in Lok Adalat. Okay. Next is obviously there has to be a pre-agreed arbitration clause or agreement. Usually for contract enforcement, you go. So in that contract only you write that in case of dispute, we will go to so and so arbitration process. Okay. And here also, like in both the cases, parties bring it out of their own will. but here there is no prior agreement needed. Okay. Here a judgment is given. In arbitration, what happens that after listening to both the parties, a judgment is delivered and then that judgment is binding. So it has more of the form of court only. Like in court, the both two party goes and then the court gives a judgment. Whereas in Lok Adalat, there is no judgment, rather there is a settlement. So some, as I have told you earlier, that you can go to the Lok Adalat and then you can decide that we are not able to find any middle path, no compromise is possible, then you can come back from the Lok Adalat, there could be no judgment as well. Whereas in arbitration, when both the party has put forward their argument, there is going to be a judgment. Okay. Decision is enforceable in both the cases, so they are similar on that ground. Appeals are allowed on limited ground and there is no appeal allowed. Okay. Whereas arbitrators are chosen by parties. This is another point, whereas they both the parties they decide that this is the person which can act as a neutral arbiter. Okay. Where on, and often they are the subject matter expert. Whatever with the matter, the expert of that matter is often chosen. Okay. And here they are often presided by retired judges or judicial officers, or even social workers are there sometimes. Here a lot of cost is involved. These arbitrators and even like advocates etc. are involved. For example, in disqualification matters, Harish Salve has represented India's case in the recent Paris Olympic. Okay, so obviously Harish Salve is very expensive advocate. So in arbitration, usually the advocates etc. involved, the cases take a lot of money is involved. Obviously, it provides a speedy justice, but here you can argue on your own, no court fee involved, you need not have an advocate, so it is very inexpensive. That's the major difference between the two. It is very much professional in nature, that is very much informal in nature. Okay, here like you need not have the formal affidavit, you need not have the formal advocate, you can simply go and argue your case that sir, I do not have money, from where can I pay, please waive off the loan. You can simply talk like that in Lok Adalat. Whereas here it is completely legal, everything is in the legal manner, only difference is it is happening in front of arbiter rather than in front of court. Is it clear? If you have any doubt in any point, please ask. Clear? Okay, so we have less time left now. Next item to be discussed is tribunals. Very briefly, I will discuss you the matters related to tribunals. Tribunals, they were, the chapter on tribunal was introduced through 42nd Constitution Amendment Act 1976, and the two articles that been added by our constitution, 323A and 323B. This is 323A deals with only administrative tribunal to deal with administration related matter. So central administrative tribunal has been established. Under this, only parliament has got the right to establish tribunal for states as well. So for central officials, central government employees, as well as the employee of a state government, parliament can establish two different tribunals, but only parliament has got the right. Whereas under 323B, tribunals can be established for all other matters, and then depending upon their respective domain, a state legislature and parliament both can establish the tribunals under this article 323B. Okay. Uh, then what happens that this 42nd amendment has also mentioned that the jurisdiction or the appeal to the high courts can be avoided by from these tribunals. In L. Chandrakumar case, the Supreme Court said that judicial review of high courts are part of basic structure of constitution. So judicial review cannot be taken away from high courts. So an appeal from these tribunals now lie to high courts as well as appeal lies to high courts as well as Supreme Court. Okay, like the NGT Act has this provision that appeal from the judgment of National Green Tribunal can lie with the Supreme Court. Okay, so here the people or the litigants, they have the liberty to either approach the Supreme Court directly or go to high courts. But not all the tribunals have this provision. Most of the tribunals now have the provision that appeal from their judgment will lie to a high court. Okay, so now appeal can lie to High Court. So the Act cannot do away with the appeal of High Court. It can allow direct appeal to Supreme Court, but it cannot say that no appeal shall lie to High Courts. I hope this point is clear. When Supreme Court has said the judicial review of High Court is part of basic structure, so it is not saying that direct appeal to Supreme Court is not allowed. Direct appeal to Supreme Court can be allowed, but you cannot take away the people's power or the litigant's power to approach the High Court. This is the current status. I have just given you the example of NGT from which direct appeal can be done in Supreme Court as well as High Court. Okay. Now, why this topic is in news these days? You can write down the definition of tribunal as well. It is like these are quasi-judicial bodies established to resolve disputes in specific fields like taxation, labor. So we have income tax appellate tribunal, we have NGT for environmental matter. So various specific matters we can have these specific tribunals. These are quasi-judicial. Why? Because they have representation from judiciary as well as administration. They are not part of the three-tier ordinary judicial system. They are not only manned by judges. They are doing judicial functions. So since they are doing judicial function, they are giving judgment, but they are not part of ordinary judicial system. That's why we are calling it as quasi-judicial bodies. They are manned by people from judiciary as well as people from administration. Since they are dealing with these special matters, so people from like the administrative member are expert member. Like in NGT, we have environmental experts member, and then we have retired judges, etc. in National Green Tribunal. So they are member from judiciary, there are member from administration, which are having expertise from the relevant field. Okay. So these are the benefits. You can say that what is the benefit that we can get? Obviously, they can give us speedy justice, because now they are dealing with only the same thing that I explained, fast track court. So similarly, they are since dealing with only that particular matter, and you do not have to go to the ordinary courts. There is a parallel mechanism dedicated to your particular issue. So they usually provides a speedy justice. Then how they provide speedy justice? Because they are not bound by civil procedure or evidence act. Okay, they can give summary judgment. Summary judgment is in contrast to a speaking judgment. So normally, if you look at any judgment of a court, there is a lot of details mentioned that these are the argument given by one party, these are the argument given by second party. Then the court agrees with the argument given by second party. Why court agrees? So all the detailings are given. That is called a speaking judgment. Okay. Whereas tribunals are not bound to give a speaking judgment. Summary judgment means they are simply one-page judgment. simply mentioning the order that the second party is right. This is also being misused a lot. A lot of corruption has bred into the system because of this provision of giving summary judgment. Uh, a lot many times it so happens that, I mean, one of my friend is an advocate. He was narrating this incident. I'm not vouching it, but this is like open secret kind of thing. That if things are compromised, then the argument, whatever be the argument, the judgment is known in advance. It is very easy for tribunals to justify that argument, because it does not have to give any justification, etc. It simply have to give the order. Whereas in judiciary, that is very difficult. Judiciary usually gives a speaking judgment. It gives all the detail. It has to justify the judgment given. Okay. And then it has the benefit of having a specialized and expert knowledge, because the specialized members are also there. We have seen that this is the problem with the judiciary. Judiciary judges are expert in law. They might not be expert in environment. They might not be expert in taxation. They might not be expert in labor issues, explosives, all those things. Okay. So these are the benefits that are there, because of which we have tribunals. Tribunals are required. We cannot do away with tribunals. Next is that there is one argument which is being said that tribunals were established to provide, to strengthen the judicial system, to act as a support. Rather, what is happening, the tribunals are acting as an independent judicial authority in themselves. They have become like a parallel judicial system. Why so? What are the arguments given? Why it is being said? So simply to substantiate this argument, you have to think what all are the things being done by the courts. Whether tribunals are also doing all the same thing. In that case, we will say that yes, they have become a independent judicial authority. So like normal courts, there is original jurisdiction. Tribunals also have original jurisdiction. In normal case, like CAT, Central Administrative Tribunal, it has original jurisdiction. In normal court, there is appellate jurisdiction. There are various appellate tribunal like income tax appellate tribunal, which has appellate jurisdiction. Securities appellate tribunal, which hears appeal from SEBI. Then it deals with the very broad number of issues. It originally it was envisaged that there would be few matters on which we will have tribunals. Now there are so many tribunals that almost every matters which deals with some part of administration are being dealt by one tribunal or another. Okay. Next is, so it is like court only, na, that there is a parallel system of court where you can take up your matter. Now it can exercise contempt jurisdiction also, which is on par with the High Court. Like normally earlier what we had, that power to punish for the contempt is only with the High Court and Supreme Court. Now this is the statement given by Delhi High Court. Delhi High Court says that the tribunals can exercise jurisdiction and power on par with High Court, contempt jurisdiction. In fact, they can regulate their own proceeding. It is not that they are bound by the proceeding being followed in any of the High Court. They can have their own rules of procedure, develop its own procedure and principles. So this is same like ordinary judicial court. Then even now tribunals are resisting the High Court oversight. There is a case when Delhi High Court ordered the CAT to expeditiously dispose of one case, and the CAT showed its displeasure to the order given by Delhi High Court. So you can write it down that now tribunals, in example you can say that CAT showed displeasure to the order given by Delhi High Court. It says that we do not come under the jurisdiction of the High Court. High Court has jurisdiction over subordinate courts, like oversight jurisdiction I am talking about. That is not the case with tribunals. And then with some tribunals, the direct appeal lies to Supreme Court. We have seen the example of NGT. So based on these arguments, we can say that obviously they are now acting as an independent judicial authority. Okay, but then all what is the difference between arbitration and tribunal? See, tribunals, arbitration is one type of tribunal. Okay, so as such, not many differences there. Both are quasi-judicial in nature, but under Arbitration and Conciliation Act, when we go for arbitration, there has to be a voluntary agreement between the two parties. So the two parties have voluntarily agreed in advance that they will go for arbitration, and then the two parties choose the arbitrator. One of the arbitrators, there is no necessity that has to be a legal member only. There can be experts. So usually they are the body expert. Okay. So all the matters under arbitration are dealt by Arbitration and Conciliation Act. Whereas in case of tribunal, it is not necessary that the both party will agree to go to the tribunal. Like I can go against the income tax. It is not necessary that income tax department has to agree with me that you will go to the income tax appellate tribunal. So I can go without the wishes of the other party. Both parties did not agree. The second thing is that these tribunal are specialized for these specific matter. Income tax appellate tribunal is but dealing with a specialist matter. I do not get to choose the judges or arbitrator. Whereas in arbitration, we both party chooses the arbitrator, that this is the person who will do the judgment. Okay, I hope it is clear. We have the paucity of time. So if there is any doubt, you can mention in the comment section. We can deal it in the next class. So that's all that we had with respect to judiciary. In the next class, we shall start with the executive, and we have already covered a lot many aspects of executive in advance, so you can revise those aspects like veto power, ordinance, etc. And then the rest of the matter we are going to deal tomorrow. So see you again tomorrow 2 p.m. See, tomorrow is Saturday, but still we are going to have a class tomorrow. For tomorrow only, usually we have class Monday to Friday, but tomorrow we will have a class from 2 p.m. See you again. Take care.